Okay, today's class is our last of the semester, and we're already starting to work on plans for next fall. So thank you for your faithful attendance, and thanks to our Zoom people who also are faithfully here each Sunday. We appreciate it. Oh. Thanks. Jeff's on the committee, so his rooting section. Thanks, Jeff. We will resume class right after Labor Day, directly after. Today we welcome Dr. David Ryden, and Dr. Ryden is no stranger to Third. He's been here before, led classes over the years. He's a professor at political science, at Hope College, and he joined the faculty there in 1994. Could you be old enough for that? In that time, he has published numerous books and articles on such topics as the Supreme Court and the electoral process, religious liberty, faith-based sector and governmental partnerships, and other questions at the intersection of politics and religion. He's the author of The U.S. Supreme Court and the Electoral Process, and another book, Is the Good Book Enough? Evangelical Perspectives on Public Policy. Dr. Ryden has a BA from Concordia College in Moorhead, Minnesota, and a law degree from University of Minnesota. And I connected with him. I'm a fellow Minnesotan, so that was interesting. And a PhD from the Catholic University in Washington, D.C. His wife, Reverend Jennifer Ryden, is an RCA pastor who is a chaplain at Hope College. And just as a note, for those that are on Zoom, there is a link to the handout that our people in person are looking at that you can follow along as well or look at after. Thank you for being with us today, David.
Good morning. I'm going to get this a little closer to you all. So I teach politics over at Hope College, and law and religion and politics. Well, first of all, thank you for having me. Thank you for the invitation. It's great to see some familiar faces, a number of familiar faces in the crowd. But as someone who studies politics and who hails from Minnesota, whose spouse is from Minnesota, for many, many years, I would tout kind of the superior good government ethos that I thought characterized Minnesota. And I really believed it. I really believed it. This reference is meaningful only to folks who are wise in years, as you all are. I held that position until they elected Jesse Ventura as their governor. And then just in good faith, I really couldn't say that anymore. But I do love Minnesota. I've already made a couple Minnesota connections today. It's still home. But I appreciate the invitation. I always enjoy coming to Third Reformed. Last time I think we were in the sanctuary, it was that dreaded time of COVID, and we all were far apart. So I much more appreciate this. You all have an outline, so I'm never have it enough together to pull together a PowerPoint. So this is my, hot off the press about an hour ago. So that's kind of how I roll. It's much longer, and there's much more here than what we will get through. All right, I could filibuster on this topic. We could be here till mid-afternoon. I tire of my own voice, and that tells me other people probably do as well. All right, so my goal would be like a hard stop in half an hour. And so then, questions. The topic is religion and the Constitution and the Supreme Court's treatment of religion in the Constitution. And that's a complicated, right? That's First Amendment jurisprudence. The trees that have been cut down to make the paper that has gone into the publishing of the books that have filled the shelves and shelves of libraries on the subject of the First Amendment religion clauses. It is expansive. And I would say it has tended to bring more heat than light. There is no topic that has more bedeviled no pun intended, bedeviled the Supreme Court and their efforts to try to sort of craft coherent jurisprudence around religion and the interaction between religious actors and governmental actors. So it's kind of a nuanced topic. You know, you all and folks online, it's something people bring widely divergent kind of levels of understanding to, right? That's just a given. And like, I'm trying to sort of pick a spot that will hopefully appeal to folks, bring folks along, not get too into the weeds, but I am prone to. But that really does put a premium then on questions, right? Questions and comments. And if I'm going to stop at 11:30, you better have them at the ready, okay? And don't feel the need to wait, right? If as we're going through things and there are ideas, points I'm making that are murky, need clarification, or don't land quite right, and you want to push back, right? Throw your hand up and feel free to ask it. Fair enough? Yep. All right, my expectations are high, people. So giddy up, let's go. So the tagline, the introduction, this is kind of the tagline. And I put it this way, that the current Supreme Court is the most solicitous of and sympathetic to religion and religious actors, more so than any other court in modern judicial history. And by modern, the modern era, I'm talking like the 1940s on. Okay, that's the time when religion really became a topic for the court. So this is the Roberts Court, this trace, right? The Roberts Court. Roberts took the chair of the Chief Justice in 2005. To give you a sense of the court's sympathy for religion, the last case involving religion that ended up in a decisive or a clear defeat for the religious claimant, 2010. So 16 years ago. Okay, between then and now, I tried to do a count. There's some discretion in terms of what qualifies as a serious religion case before the court. Most cases that get to the court are serious. I counted 17. The record for the religious claimant in those 17 cases, 16-1. Okay, 16-1. And it's probably more accurate to say 16-0-1. That the one was actually not a loss, it was a tie. The court was down to 8. Associate Justice Amy Coney Barrett recused herself for a potential conflict, and so the 8 ended up in a 4-4 tie, right? So even that one was a coin flip. All right, so empirically, that sort of gives us a sense of this court's sort of pro-religion attitude, all right? Number 2, let's make sure we know the language we're talking about, okay? And you all probably know it well. It's the first set of clauses of the First Amendment to the Bill of Rights. So Congress shall make no law respecting an establishment of religion or prohibiting the free exercise or abridging the freedom of speech. All right, so 3. Up until a few years ago, I would say 2 relevant provisions, religion clauses. Now there are 3. The free speech being the third, right? So the first one, we call it the Establishment Clause. That refers to kind of church-state relations. That's what we're talking about when we talk about church-state separation. Establishment Clause. Okay, Congress shall make no law respecting an establishment of religion, right? Or prohibiting the free exercise thereof, Free Exercise Clause. And there we're talking about religious liberty, right? So church-state separation, church-state relations, religious liberty. And then, as a few years ago, we have the Free Speech Clause, that has become an additional way in which the court has sort of invoked speech protections for religious behavior. Okay, and we'll get into, I'll give you some examples of that. So, point number 4, recent trends in religion. And so I'm going to go through, I don't know if I'll hit on all of these. I'll try to limit them to maybe the most significant ones. And my goal too is to kind of throw in enough cases to liven things up a little bit and to give you a sense of like how these provisions actually work out, the kinds of questions that go before the court, that end up before the court, and what it does with them, okay? So trend number one, when we're talking about judicial attitudes towards religion and the government, the spectrum, we use the language of separationist and accommodationist. And you have a spectrum from separationist to accommodationist, right? Separationist, that's the Jeffersonian language of the wall of separation, right? This idea of a high and impregnable wall of separation between religious and governmental actors. Strict separation. And then on the other side, the other end of the spectrum, we have accommodationist, meaning the courts are more accommodating of, more willing to allow some interaction between religious and governmental actors, okay? So it's helpful to just kind of use that language. It's a little simplistic, but you can invoke that at dinner parties. You can talk about how accommodationist the court has become in recent years. That's been a clear shift from separationist to accommodationist. Okay. Point number two, the court has gone from stressing Establishment Clause questions, separation of church and state questions, to stressing free exercise. And so recent years, the Establishment Clause has been subordinated, I would say, to free exercise and religious liberty consideration. So as the court has become more accommodationist, it's worried less about separation and more about protecting religious liberty. Okay, let me kind of compare a couple cases to give you a sense of that, right? So before or early on, I cited Locke v. Davey, 2005. That's on sort of the prior emphasis on separation. And then I'll compare that to this trilogy of cases in recent years that the emphasis is on free exercise, okay? So Locke v. Davey, 2005, so right at the end of the Rehnquist court, Chief Justice Rehnquist actually wrote the opinion in that case. It involved state of Washington law that provided scholarships for people to go to college. It was like a scholarship program, okay? And the terms of it excluded using those scholarships for what the state called devotional degrees, okay, under the terms of the statute, okay? Mr. Davey applies for the scholarship, gets the scholarship, and is going to use it to go to a small kind of Bible college where he will be trained to be a pastor. And the state looks at the statute and says, "Nuh-uh, can't do that, right, under the statute, can't do that." And he sues the state based on sort of free exercise. Okay, and the court, in an opinion written by conservative Chief Justice Rehnquist, sides with the state of Washington. It says, yes, it upholds that statute, excluding, right, the use of the scholarship for those religious purposes. Okay, and it's a really interesting case. Chief Justice Rehnquist uses this phrase, play in the joint. There has to be play in the joints between the Establishment Clause and the Free Exercise Clause. And he says, Washington, if it had wanted to, it could have included people like Locke. Not Locke, like Davey. Right? They could have included him. It wouldn't have violated the Establishment Clause. But it is not required to under the Free Exercise Clause. And the state has the discretion to exclude if it is worried about church-state separation and it wants a more of a separationist approach, okay? So the Establishment Clause, they could have done it, but not required to by the Free Exercise Clause, and he sides with the state, okay? This trilogy of cases, 2017, 2020, 2022, so that's in the last 8-9 years. Remember, in Supreme Court constitutional terms, that's like yesterday, okay? Changes in the court are gradual. They move at a glacial pace. So don't think, oh, 2017, that's many moons ago. No, this is a recent development, this trilogy of cases that put the emphasis on free exercise of religion. And each of these were cases where states provided benefits, generally available benefits to the people of their state. And those programs said, religious applicants do not qualify. So religious individuals or entities need not apply. Okay, and each of the three cases, religious individuals or entities brought suit for being excluded, and in each of the three instances, they prevailed. Okay, to note that shift, right? So in Trinity Lutheran, that involved a preschool, a private preschool attached to a Lutheran church down in Missouri, I think it was, right? And the program was a state program to take old tires and to recycle them. And to recycle them into playground surfaces, these like spongy, kind of bouncy playground surfaces. The idea was to deal with the issue of tires and also safety, right? Safety on the playgrounds. And Trinity Lutheran applied. They had a program that by all the criteria ranked very highly, but they were denied by the state. Okay, and they brought suit, and the Supreme Court now said, free exercise says if this is a generally available benefit, you can't deny it to a school because it's religious in identity. Right? So now in that case, it dealt with rubber playgrounds. It's like, okay, well, that seems okay. What does that have to do with religion? But you go to Carson v. Macon 2022, and the issue was state money. This was in Maine, where very rural, dispersed populations, a number of areas where there are no schools. And so families have to figure out ways to get their kids to neighboring school districts, and the state had a program to help pay for that, to subsidize. And the state law, the state program said, no, religious families, you can't avail yourselves of that benefit to send your kid to a parochial school. Goes up to the court emphasizing religious exercise, religious liberty, said you cannot exclude a religious claimant just by virtue of their being religious. Now in that case, if you're worried about separation, now we're talking about religious instruction, and this being, right, it seems a little more proximate to the religious kind of programs that the government is maybe involved in supporting. But that sort of indicates the kind of shift that has happened. Okay? Make sense? A couple rules that come out of that. One is, and here if you want to impress your friends at the dinner party, the withering, if not the death of Blaine amendments. Anybody know what Blaine amendments are? Okay, yeah, Blaine amendments are provisions in state constitutions that say state money from the state treasury cannot go to religious institutions. Okay, these Blaine amendments are called Blaine amendments because James Blaine, Republican running for president, 1874, thought he could ride anti-Catholic sentiment to the White House. And so what did he do? He wrote and introduced to Congress a provision, a proposed amendment to the Constitution that would have said that, right? No public funds to sectarian institutions. And everybody at the time knew what sectarian meant, right? It meant Catholic, because we're starting to get this concern among Protestant America, right? The growing 1874. Okay, it passes the House, fails the Senate by, I think, a couple votes. That's not the end of the matter, right? It shifts to state legislatures where a large majority of states pass those what we call mini Blaines, right? Precluding public funds to sectarian institutions. Historians are pretty clear those are motivated by anti-Catholic bigotry, right? Anti-Catholic sentiment. Okay, in these modern, but they persisted, right? They persisted as meaningful provisions in state constitutions to preclude public money to private religious institutions. Okay, the case of Trinity, Espinoza, Carson mark the decline, if not the death for all practical purposes of those Blaine amendments. Really interesting development. Those cases have advanced. What is this? So if there's one takeaway as you think about religion and the government, the rule now is neutrality. And whether it's the Establishment Clause or the Free Exercise Clause, neutrality, neutral treatment of religious and secular entities and individuals. Okay, that's the principle, neutrality. All right, and so what it means is government can direct benefits to religious entities on the same terms as their secular counterparts. Right, that's neutrality. Now they can't say, "Oh, Christian schools get this, but Jewish schools don't." Right? They can't play favorites among faiths or among denominations. Neutrality also means, right, neutral treatment between religious and secular, but also neutrality between faiths and denominations, okay? Next, so here's where the third provision comes in, the rise of free speech as an applicable restriction or an applicable protection for religious behavior, right? Kennedy versus Bremerton, this one made the headlines. You may have remembered this from a few years ago, the praying football coach, right? It was a public school. I forget where it was. He was the defensive coordinator of the football team, and he got into the habit of, after the game, he would go out to the 50-yard line and take a knee and say a prayer. And gradually, some people in the stands saw that, and they some came and joined him. And then, of course, players started to come and join him in the post-game prayer. Well, there are also others in the stands who looked at it and said, well, that doesn't seem right. And they brought their complaints to the school administrator, who tried to get Coach Kennedy to stop it. And those efforts proved unsuccessful, and they fired him, at which point in time he sued. Okay, and that works its way up to the Supreme Court. He ultimately prevails, okay? And he prevails on free exercise, but also especially free speech grounds, okay? And the court says, no, he really was not wearing his coach's jacket, right? He had ceased his, right? If he was clearly a coach and was a representative of the school, then that's public advancement of religion. That would be a free exercise problem. Right? They say, no, by the time he's going out afterwards, this is him as an individual engaging in free speech. Okay? Free speech as a protection. All right? Second really interesting category are what I call the wedding vendor cases. Right? These are the cases involving the Christian cake artist, or the Christian web designer, or the Christian printer of the programs, or fill in the Christian photographer, right? The video editor. And there have been several, right? Masterpiece Cake Shop was the most high-profile case, then Creative 303 Creative, other cases going through the court systems where it is kind of religious small business owners providing those services, and they are rubbing up against state public accommodation laws or non-discrimination laws. Okay, and so oftentimes, typically, it's a case where they are being asked to bake a cake for a gay couple, right? Or to do the web design for a gay couple who are getting married. And so the objection is a religious one based on their traditional understanding or biblical understanding of marriage, right? And you have, this has maybe been the central conflict in this area over the last decade, is a conflict between, right, expansive non-discrimination laws on the one hand, right, and religious liberty, kind of the assertion of religious liberty claims on the other. Okay, but it's religious liberty that also perhaps involves speech. So if you have an hour to kill this afternoon, go home, hop on SCOTUS blog, and pull up the oral argument to 303 Creative. And the court just spends forever on what qualifies as speech. Right? Is a cake artist who puts his own creative designs on the frosting, is that speech? Right, the web designer who creates the website, is that speech? A caterer, well, that seems less like speech. The person who does the beautiful settings in the middle of the table, is that a form of speech? Right, really interesting and kind of gnarly questions that the court is trying to get at. Okay, and this is sort of an open area, so there's a lot to be determined there. All right. Next bullet point: religious liberty versus non-discrimination, and the importance of religious exemptions. Okay, so again, the conflict here is between non-discrimination on the one hand, right, and a claim that one's religious beliefs mean they cannot comply with the provision, right? So the Hobby Lobby, this was a high-profile case coming out of the Affordable Care Act, right? The Affordable Care Act, one of the requirements by Health and Human Services that if an employer provided health care, they had to include abortion services in the health care, right? Hobby Lobby is the Green family, evangelical Christian family. They objected to that on religious grounds. Okay, and the law had a very narrow religious exemption for houses of worship, right? Basically for churches. Okay, and the Green family was saying, well, no, as a business person, as someone who runs a business, right? Religious liberty should extend to how I decide to run my business. And so it's a question of how narrow or broad might exemptions be to non-discrimination provisions to allow for the exercise of, for one to run their business or their nonprofit or fill in the blank to run it in a religious fashion. Fulton versus Philadelphia, same issue around adoption. Okay, and so it involved the city of Philadelphia and their referral process, and Fulton was a woman who just had a lovely history. She would adopt dozens of kids, right? She was a conservative Christian. She wanted to use the Catholic Adoption Agency that had been a referral service for the city of Philadelphia forever. Okay, somehow a newspaper, this wasn't even a real conflict, it was a hypothetical conflict, right? A newspaper article, a reporter asked someone from Catholic Social Services, would you place someone with a gay couple? And Catholic Social Services, right, in line with kind of Catholic teaching, Catholic social teaching, said no, we would not do that. We would refer them to another agency. That made it to the news. The officials of Philadelphia decided to make a fight out of it, even though there was never an actual case. And so they kicked Catholic Social Services out of their array of providers, goes up to the Supreme Court. Supreme Court says you can't do that, right? As long as they are able to sort of refer someone to another provider, there needs to be a meaningful religious exemption, right? So that's really an important, again, an important kind of live issue is how do lawmakers, state legislatures, Congress, how do they balance, right, non-discrimination, right, legitimate non-discrimination with also kind of meaningful exemption for religious claims. Okay, really important issue, all right? The other one then is the rise of the, what's called the ministerial exception, okay? And this is another development where the court has said religious entities and the autonomy, free exercise, that provides a good deal of autonomy for religious institutions to operate free of like employment laws, okay, non-discrimination laws, okay? And the rule of thumb is if, and so the cases that are involved here involve a religious school that ends up firing one of their teachers for reasons I don't need to go into. She files a lawsuit under federal non-discrimination law. Okay, and they say, no, we're a religious institution, we get an exception. And the rule of thumb, whether they get the exception or not, is the person a minister. Now, not minister as in like pastor, reverend, my wife the chaplain, right? But is it someone who has some meaningful role in perpetuating the religious mission of the institution? Okay, so one of these cases involved a teacher at a Catholic school, and she would lead Bible studies. She would be a chaperone for kind of religious day trips, a number of other things. So she wasn't a minister as right in the usual sense, but the court said no, she has a meaningful role in sort of the mission of the religious school. Okay, ministerial exception. All right. All right, so let me just, number 5, let me take 3 or 4 minutes to hit a couple of these. These are sort of larger implications, and like hopefully you'll have some questions or thoughts on these. All this stuff I've just said, well, like, what? So what? Like, what does it mean? What's the significance of it? Bullet point number 1, this court, a more religion-friendly court, clearly has a more expansive view of what is religion. So a long time point of difference has been, like among the justices, is religion a private enterprise, right? Or is it a public enterprise? Okay. Justice Ruth Bader Ginsburg, you can look at her writings on religion cases. She understood it as private. Right? And so hence a much narrower view of what's protected religious practice, right? We can see in some of these cases I've mentioned, the more conservative justices have a broader, more expansive view. So how someone runs his business or her nonprofit, right? These are ways in which people practice their faith. Okay, a more expansive view of religion as public. Second, the court is clearly open to the expression of religiosity in the form of symbols, imagery, right, paintings and crosses and creches in sort of out in the open. Okay, in the public square. So a second big question, right, is the role of religion in the public square. And this court says that's right, that should be much freer for people to express that. Okay. Dropping down 1, 2, 3, the 4th bullet point. So as we think about, I titled this like what it means for the church. I really haven't gotten there, so we're gonna have to figure that out. But one of the really interesting things, and I'd be curious what people think, is we have 2 broad trend lines that are headed in opposite directions, right? So in the last 15 years, it is just increased protection in how we read the Constitution and apply it for religious actors and individuals. Okay, greater judicial protection. And then the opposite trend line, right, in the opposite direction, is what is going on with religion, formal religion in our culture, right? And you all probably are familiar in the last 10, 12, 15 years, really kind of stunning decline in the affiliation, right, with a church, a faith, a denomination, significant decline in practice, church attendance, participation in Bible studies, and all these sorts of things. Is that sustainable? Right? Are churches that are withering and shrinking, right? Is there going to be a tendency to sort of look inward because, oh, the court has our back? Or like, what is, will churches still be motivated to be a public witness and to not rely on judicial protection? I'm not sure I'm saying that well, but there's something interesting going on there, and I think, yeah, it's something to keep an eye on. And then the other thing is what I call the God gap, and this is become sort of a stunning, sort of jaw-dropping gap between the parties and their religious participation. So if you want evidence, I used to say, yeah, the 2 parties, the conservative party the Republicans tend to be more religious in practice, but guess what? In the Democratic Party, right, there's still large swaths of people of faith. That is becoming less accurate a way to put it. Right? So Ryan Burge, if you want evidence, he is the man when it comes to empirical studies of religion and what's happening with religion in America. And he went back and he did the 2024 presidential election, and he broke it out, the party vote for the Democrat and the Republican by religious practice. Right? And the percentage of people who engage let me see, I should have double checked this, right? Those who cast a vote, a Republican vote, overwhelmingly in the 70-something% went to church on a weekly basis, okay? Those who cast a Democratic vote, the percentages who went to church on a weekly basis, if I remember correctly, under 20%, which is jaw-dropping, right? Kind of in Western Michigan, right? Churches flourish, and we have churches that lean always. We're kind of, we're not typical, right, of a lot of places. That kind of gap, like really concerned, if I'm someone who believes religious liberty is really important, right, and I don't want it to be a lightning rod, right, kind of culture war division between conservative and liberal, Democrat and Republican, right? My fear is that might trigger one more thing that just gets eaten alive in this polarized environment within which we operate. How far will the court go? One additional case that is really interesting. This is the case, Oklahoma Charter School Board versus Drummond. This was the case in 2025 that ended up in a tie. Okay, and it was a case where the state of Oklahoma sought to create a virtual, an online Catholic charter school. Okay, got that? Virtual, online, Catholic charter school. So charter school, public funds, but fully Catholic, right? And it was interesting because even the leadership in Oklahoma were divided. Like the attorney general was for it, and the lieutenant governor was against it. And they were all Republicans, right? But it went to the court. Amy Coney Barrett, very devout Catholic, who had friendship with the law firm that was litigating it. She withdrew, and it ended up 4-4. And I throw that one out there because, number one, I think that shows, wow, establishment clause, like, I'm pretty uncomfortable with that, right? That sure sniffs of an establishment to me. But that case is coming back. And Amy Coney Barrett, if she, how's that going to go? I don't know. So that, I think, sort of capsulizes, kind of where this court is at and just how far they might go. All right, not bad. So I went an extra 5 minutes, but we got 10 minutes plus. I'm willing to linger. All right, comments or questions or thoughts? Don. I'm going to...
Is this causing or is it following the vastly increased partisanship and lack of vision of the public good? I think particularly of all these cases involving education, public education was one of the main creations of this country to foster a commonality and a common experience and a common commitment to the common good. And all these cases that you cited really says it's more important that I get my way than that we contribute to the public good. I think that's in other cases too, but especially in the education cases. So this partisanship that we've had for the last 10 or 15 years, was it caused by these kinds of decisions, or do these decisions reflect the increasing partisanship?
I wouldn't go too far in trying to make a connection between this development we've spent the morning discussing and the partisanship, right? Like among conservative justices, there has been a pretty principled, I think, interpretation and application of the religion clauses in the Constitution. And it goes back into the 90s. So that was there. And I'll put my cards on the table. I tend to think the court is probably pretty accurate, pretty right as a legal and a constitutional matter, right? But please don't interpret that as me saying, as a policy matter, that is right? I think that's where it really gets murky and complicated and where I would have some pretty serious problems, right? But I do think their sort of constitutional approach, how they're, right? This is an instance where originalism actually has some currency, I think, in deciding the religion clauses. So I wouldn't go too far in making that connection. I will say this, and again, take this with a grain of salt. This is sort of me musing aloud, is that among the members of the court, their position on the First Amendment religion clauses and what they compel match up to their personal religious attitudes. Right. So the conservatives tend to be practitioner. They tend to be religious in an active way. The liberal justices tend not to be. You know, I've studied the courts long enough to not be held in sway by too formalist an approach to justices merely operating like by objective principle of constitutional law, right? They have blood in their veins, and their commitments and convictions and values very much shape what they do. Right, so I have often thought, and I love to kind of compare Ruth Bader Ginsburg as a secular Jew, right, to Antonin Scalia as a devout Catholic. Right, and so on that question of sort of religiosity as more private versus public, their views are going to be very different. And I do think they match up. One's is going to be more sort of intellectual. The others, I don't know how he can decide without his view of religion as being like shaped by his kind of personal commitments. Does that make sense?
But I don't hear in your decisions any respect for the public good. There's a trade-off. Private schools versus public schools. That has nothing to do with religion. Do we want to sacrifice any of our liberties in support
Right.
of good?
Yeah.
Living in a country
Yeah.
as well.
Yeah. No, I think that's a legitimate policy question. Absolutely. Yep. Yeah.
Good. So if you talked about the glacial pace of Supreme Court precedent,
Yeah.
The shadow docket is kind of accelerating. In the space that we're talking about, the domain we're talking about here today, does the use of the shadow docket change what we're talking about?
Yeah. So real quickly, do people know what the shadow docket is? These are cases that don't follow the normal track through the appeals process that typically takes several years, and kind of things simmer and they stew and they mature, right? In the era of Trump, his use of executive orders, those being challenged in courts, right? A lot of these issues are front and center. They have taken on a sort of an immediacy, and that tends to then get to the court much more quickly through what we call the emergency the emergency docket. It's an accelerated review of a particular issue where an executive order typically has been challenged. It's before a district court. A lot of kind of judge shopping happens. So those who are challenging the executive order are going to find like a sympathetic sort of district court. And so then it ends up like, if the government loses at the district court level, they may choose to file for accelerated review under the emergency docket. And that's been this relatively new and it raises lots of concerns. We don't have a chance to get into that today. It's a complicated mess. All that to say, no, the religion cases it really has not impacted them. This has tended to be through sort of the normal process, appellate process. Yeah, Jeff.
So this might be a comment more than a question.
Sure.
When I think of the Supreme Court right now, I think of the dismantling of the Voting Rights Act. And I see them doing all these kind of culture war things, and they feel trivial. And the Voting Rights Act feels really significant. And so it feels to me like if I was somebody that was on the fence about religion, and I saw this is a religion, I would run away from religion. That's my comment.
Yeah, so I have a fundamentally different view on the voting rights stuff. I think it's much more nuanced and complicated. Would love to do a HASP session or something where we could really work it out. I think the more important point you make, though, Jeff, is like, and this is maybe for the church, is like, how do we worry about what do we think of our public witness? right? And what has worked more against the public witness of the church, right, than this inclination to merge one's political, right, for religious people in churches to merge their faith with their politics and who they're following. And that has done great damage to the church. So I will acknowledge that's a really important thing, I think, yeah. The voting, I mean, that's kind of outside our purview. So I would love to, in another setting for us to, that's a really interesting one. Robin. Oh, I'm sorry. Are people okay going a little after 12:15, or do we have to wrap it up? Okay. If people need to go catch a bus or do whatever, feel free. I'm happy to linger if people want to. Yeah.
I'm wondering if you could comment on the spate of new kinds of ideas that it seems like there's the new message is this was founded as a Christian country. And how is that going to impact what's going on with all of this litigation?
Yeah. You know, I don't, right, I mean, we're getting into the sort of the Christian nationalism debate, which is, boy, that's another session we ought to have. I mean, to the extent the court has done history, it's been pretty good, right? It's been pretty good. So if we take the clear sort of classic definition of Christian nationalism, the court and the Constitution are very clear. That's a violation of the First Amendment. It's a violation, right, of the ban on, right, religious office holding and that sort of thing. So I tend to be, that's more of an issue for the church and the culture. Yeah, yeah. Right. Yeah, I don't like that. Yeah.
What can you say about the definition of what counts as a religion?
Yeah.
So if Wicca wants to put up something in the public square, or other people who will call themselves religious, are they expected to enjoy the same rights?
Yeah, great question. So in my Minnesota vein, last Christmas, our family went to visit family in the Twin Cities. It was the day or two after Christmas. We were looking for a way to kill some time. My brother lives a mile from the St. Paul Capitol. It's a beautiful capital. It's a beautiful state capitol if you haven't seen it. And so we wandered over and kind of spent a couple hours wandering through the Capitol building in St. Paul, and right in the rotunda, there was one group of evangelical Christians here, and they had a tree and signs. Over here was the Satanist group with their demonstrations. I mean, our system, so two things. Point number one, it's pluralist, right? We are pluralists through and through. So one challenge is keep an eye on the court and others and to see, is there a respect for pluralism, right, in terms of who's entitled to these protections, right? Again, the court's done pretty well. So when you look to prison populations, for example, and it might be a Muslim prisoner, there are various, a lot of times the religious liberty claims will be from minority faiths, right? And the court's been pretty good at protecting those, right? There is this larger question of, well, what qualifies as a religion? Anything and everything, right? Ryden can go out and create his religion, his church of one, right? Is that going to entitle me to kind of governmental protection to take advantage of all these exemptions? I would try to define, there are ways in which one can really try to say, no, this is a religion. Are there the trappings of institutionalism? Is there a creed, right? Is there structure? Are there different things that we would tend to think qualify as a religion? So I could go on at length on that. But because that's an open question. And the court has never done a really good job in saying this is what qualifies as religion. Yeah.
Dave? Oh.
Yeah. If there's a couple more people who haven't asked questions, can we do that or? No. They're going to shut me down. Anybody here who wants to stick around for a couple minutes, feel free.
Yes.
Okay.
Yes.
But if anybody wants to remain in the cheap seats, I'm happy to.
Thank you
do
so
it.
much for being here. We
Thank
appreciate
you.
it.